Hey, Dan.
Good evening, Joe.
Hey, everyone.
What's up? So, Dan, the only comments we got was from ZBA. Is that basically it?
Those were the only comments that we have not previously discussed. So
Oh, okay. Yeah.
Joe, since you're the first one on video, can I task you with minutes?
Sure.
Thank you.
I don't know how good they'll be, but I'll do it.
They don't have to be particularly detailed.
All right. Can I write down that there's a cat in the background on Tom's video?
I thought it would humanize me. I rented the cat for the evening.
Oh, yeah.
Yeah.
And we'll get started here in a moment. Sorry for the barrage of emails with attachments and everything today. Just trying to get everything organized, and some of the stuff had to be created late. Welcome, and it looks like we've got someone who's joined with the name currently says iPhone 2. I don't know who that is to know whether we have a quorum or not. You have the ability to unmute. Okay, I believe that we now have a quorum. 1, 2, 3, 4, 5, 6. We have a quorum. So I'm not sure who there's still a person listed as iPhone 2. Kevin has graciously, Joe has graciously agreed to take the minutes. So Joe's on the hook for the minutes for tonight.
Under protest.
Do you have signs up in your lawn, like, most of the town that say no more minutes, just hours?
No.
Sorry, it was a bad timing joke. So you know it's going to be a fun meeting when the meeting starts with bad puns.
The only thing on my lawn is a skeleton.
You are aware that we do have the town council on, and if he hears that there might be something that is required, he might be, have to report. If you've got a skeleton on your lawn, if you could, oh wait, it's October, so I suppose it's that type of skeleton. Okay. Okay. Auto transcription is turned on. Meeting will be called to order at 7:03. We have a quorum. Thank you everyone for joining. We've got a lot on the agenda. We've got some additional information, some that came in a little bit late. I apologize for that. Just so we could get the information ready so we can take care of some of the administrative things that need to happen just as part of good governance. So first thing for today's meeting is public engagement. And I'm not sure who iPhone 2 is. If you want to rename yourself or unmute, if you have anything that you'd like to contribute, you're welcome to do so. Tom, you also can qualify as a member of the public at those times that you wish to. So if you have, if either of you have anything that you'd like to add at this point.
No, I've said all I want to say.
Okay, so the town barrister is staying silent on this. I am going to make a note for the record, Joe. You may want to record this if you wish. The town barrister is not wearing the powdered wig and robes as has been previously agreed. And for what it's worth, this is an ongoing issue. Even in the prior bylaw review committee, he was referred to as the town barrister and he had agreed to wear robes and a powdered wig at that time as well. I was looking through some old information for some crazy reason and ran across that. It was rather amusing.
But no one's calling me my lord or my wife, my lady.
We'll leave we'll leave the my lord to your wife and the my lady to you.
Okay.
Okay. With that, we have two sets of minutes. For minutes for August 15th, I could not find a prior set, so I quickly created a set so that we can meet our requirement of having minutes that are set and drafted and at least submitted for approval. At this point, we have the ability to defer them and or replace them, but this way at least we have them for discussion. That becomes important just for compliance with both our bylaws as well as the open meeting law as well, or we can take a vote to accept the minutes from August 15th as well. I created these just by going through the Zoom meeting. I know how much fun we all have in the Zoom meetings, let alone to do it again. And I just tried to create very basic minutes, but containing the substance of what was discussed. It does have the required elements of who was there, the votes that were taken, and time that it met, time that it adjourned, and the location of the meeting itself. So with that, do we have a motion or discussion for August 15th?
I move that we accept the minutes of August 15th as written.
Do we have a second?
A second.
Okay, so Joe's made the motion, seconded by Catherine. Any discussion on these minutes? Going once, going twice. Okay, with that, we will take a roll call vote. And Joe, if you can note in the minutes that all votes are done by roll call. I tried to set an example in these minutes, even though they're short and relatively brief, they should contain all of the required elements, such as this is a vote by roll call. If it's by roll call and it's unanimous, you can state that, because then it becomes obvious that everyone in attendance did vote. If there's anything other than that, it has to be who voted in what direction. So with that, I'm going to go by the order that I see it on my screen. So Joe?
Yes.
Lucy?
Yes.
Catherine?
Yes.
Tim?
Yes.
Kevin?
Yes.
Lisa?
Yes.
And myself, yes. I don't think I missed anyone. Did I miss anyone? Okay, with that, we have unanimous approval. Minutes for August 15th are approved. I will then send those along to the town clerk as the official record keeper of the town, and a copy also gets sent to the town administrator's executive assistant, otherwise known as the person who helps coordinate all of our meetings. Sherry is amazing with all of that, and she will do the posting to our website as required by our own town bylaws. So that brings us to the next item, which is October 3rd, 2022. These are the minutes you should have received by email earlier. One change as we go into this that I will note is the date of the meeting was October 3rd, not October 2nd, as stated on the document itself. I think that's just a Scrivener's error, nothing of significance for that, but that's one of the things I noted. So with that, do we have a motion to accept the minutes for October 3rd, 2022.
Yeah, I'll make a motion that we accept the minutes as written for October 3rd, 2022.
Okay, so we have motion for October 3rd. Do we have a second?
Second.
Okay, seconded by Kevin. And again, I'm going to make the amendment or correction for the Scrivener's error on for the date itself to be October 3rd. Any other comments, changes, thoughts? Unless everyone really wished it was Sunday. We could move our meetings to Sundays. There's no prohibition on Sunday meetings. Not sure we would necessarily get a quorum to attend. Okay, with that, no further discussion. We will again take votes as I see people on screen. Joe,
Yes.
Tim,
Yes.
Lisa,
Yes.
Lucy,
Yes.
Kevin,
Yes.
Catherine,
Yes.
and I vote yes. Those minutes are approved. Excellent. I'll get those updated and again get those sent off as well. So that brings us over to chapter 9, which we're again coming back to. There were several notes sent out to the committees, boards, committees, commissions, public bodies by the town administrator, and that was requested to be sent to all of the various boards, committees, commissions, and otherwise named groups, and they were all asked to give feedback. Several notes were sent out. We did receive a little bit of feedback. I did send over a note that we received from the Zoning Board of Appeals. David Hatfield did have some feedback. I believe we may also have feedback from the Permanent Building Committee as well. So first, the comments that were submitted through the Zoning Board of Appeals by David Hatfield, and this was sent to all of the members by email. There were 4 comments. The first one was, why are only a few of the town's boards and committees mentioned in the bylaw? Under general references, there are notations for Council of Aging, Town Council, but otherwise there's just a few of them that are listed, and the reasoning for. It's a valid question. I think we actually addressed this in prior meetings, in the September meeting in particular, where really a lot of it just has to do with legacy reasons and not having to change that unless there's other thoughts, other historical background. Comment number 2 was after section 9-18, could there be a section saying that no appointment is effective until the person is sworn in by the town clerk? And Tom, this one probably goes to you as to, is there a legal standard as to when a appointment becomes effective itself?
Yeah, well, technically everybody who is appointed or elected as a town official has to get sworn in. So I don't know that making a bylaw to that effect would have any legal significance.
The only place where it might have importance is actually in the determination of a quorum. And although it does state for the appointed that the oath is actually specifically listed because that was previously considered on 922. The other comment, the next comment that was made was also related to a quorum, is how is a quorum determined when a board or committee has alternate or associate members as well as full voting members, such as the Zoning Board of Appeals. They've got 5 voting members, 3 alternates. Is it determined by 3 of the 5 full members or 5 of the 8? How should that be determined, and should that be added to our quorum definition?
So again, I think this is governed by state law already in that we have a 3-person ZBA. It has alternate members who can fill in in the event that somebody is absent for a hearing. And so long as the alternate member is there to fill in, then there's not an absence that is up to two of these alternates can fill in for missing members.
And so to that point, would it be helpful in clarification that alternate, would it make sense for 922, where in section 922B, where it currently states for appointed multiple member bodies, greater than 1/2 of the total number of appointed members who have been appointed and taking the oath to serve. I'll share my screen in just a second here on this. The question that I have is, would it make sense to potentially add in phrasing that says alternate members are excluded from this unless they are considered active for the purposes of voting on an issue due to an absence or some other reason? I'm not sure whether it's necessary, whether it'd be helpful, but I think that's what they're trying to, what the guidance that's being requested.
I mean, I guess my thinking is that we shouldn't pass a bylaw unless it's going to have some kind of effect. And if it does nothing more than restate existing state law, because it can't be inconsistent with state law, then why bother? We can only do harm.
Okay.
Yeah.
So what I'm understanding, and iPhone 2 looks like Bob Vincent. So welcome, Bob. Glad to see you. Hope that you're doing well. So my understanding of what you're saying is that an alternate member, by definition, is not considered an appointed member if they're not actually active for that particular meeting.
Right.
So making that change, if I'm understanding you correctly, would not have any meaningful impact. And it may be up to the adjudicatory bodies that have this issue to understand what that means for them. Because I believe it's just the ZBA, possibly the Concom. Are those the only ones that get affected by this? Are there any other bodies that are affected with alternate members by state law?
The Concom only if I'm not. I think the Concom actually would require special legislation to have voting members.
Okay.
Yeah.
Is ZBA the only one that has alternate members in this way?
Alternate members for purposes of voting, yes.
Okay. So what I'm hearing is you're not recommending any action on this comment.
Yeah, I think that we probably don't need to do anything.
Okay, and for comment number 4, recommending updating the section to consider that if a board or committee is a secretary, then they may be the person who takes the minutes in place of the chair and submits them to the town clerk and has them posted on the town website. Certainly true for the Board of Appeals. And what that's referring to is a copy of the minutes shall be sent by the chair of multiple member body. And my reading of that is that effectively that becomes a delegated responsibility from the chair. So I think the language here is probably okay. It's just a matter of if people think that if people are reading it in a way that it is exclusive, that only the chair can, then it would be problematic, unless I'm misunderstanding the reading, because obviously whoever has submitted them can they just have to be submitted, and it puts the responsibility on the chair to make sure they are done.
Yeah. Right.
Is that a correct interpretation?
I think so. I think it's important to pin some ultimate responsibility on somebody, and the chair is an obvious choice. But that doesn't mean that the chair necessarily has to do it himself. He just causes it to be done.
Okay. which is consistent with our committee as well. Ann Santos has sent some of the minutes on to the town clerk and or Sherry Dalton. I'm not sure who she sent them to, so that they can be recorded properly. So, okay, so I'm taking it that no changes here. These may be questions. If possible, it may be something that I will respond, if it's okay with the committee, on behalf of the committee with these comments. And I'll copy you, Tom, so if there's anything that requires clarification to the ZBA, you can make sure that it is legally correct.
Sure.
Because I'm not a lawyer and I'm not trying to act like one. I leave that to our town barrister. Okay. Any other comments on chapter 9? I believe we do have an additional person from the public. If they'd like to speak, they're welcome to. Okay. That brings us over to chapter 36. So Eric did submit a series of comments after the last meeting. I forwarded those on, and those were not much specific opinions on items for discussion. He did send some of those today, knowing that the discussion may or may not, there may be difficulties with Zoom, but in the interest of the open meeting law, I didn't feel appropriate to send those in advance of the meeting because they are specifically on the agenda for today. But these were actually the items that were sent in the email earlier today were very specific to the meeting that we had last time. So that's what that was regarding. So I'd like to give Eric the ability to make his own recommendations and requests. So my recommendation is that we postpone that discussion until next time so that he can advocate for changes in other discussions. I don't want to try and speak for Eric on this issue. Chapter 36 meetings is something. 36 and 51 are items that he takes particularly close look at. We've not received any feedback yet from the town moderator on meetings either. So I have reached out to him to request some additional components, and I did send him notes from our last meeting where we made discussions about things such as 2/3 vote and so forth, and I have not heard anything back. Anything further on chapter 36?
So Dan, just to be clear, we're just gonna table this till next meeting? Is that?
Correct. We'll revisit it.
Okay.
And there's no urgency to get these closed out. So the idea of keeping it open, if people have feedback. Chapter 36 on meetings may make sense to be revisited at the first meeting in December after the town meeting, so that it'll be fresh in our minds.
Yeah, I mean, we got 40 years to do this, so.
Okay, that brings us to an interesting thing that has come up, and that's chapter 175. And I know, Tom, that you've had your hands in this, the proposed street name change bylaw. So this is something that is being submitted by the planning board to town meeting. It is not a zoning bylaw. It is a general bylaw, being proposed as chapter 175.11. I sent everyone a copy of the bylaw as it came from the website for the planning board. I did attend the planning board's last meeting. My suggestion to them personally was that they take the issue and give it to the bylaw review committee for review prior to the town meeting, and that way we could have words and go through our process with it. They chose to take a vote, move forward with it. They felt that it was urgent to do so, which is absolutely their right. And so therefore it is being presented as a warrant article in about 1 month at the town meeting in November. So with that, we do have the ability to examine it, and there can be changes. There's an opportunity, as I see it, for us to improve a bylaw that is being proposed, because there are some things in it that, just given our nature of being very specific, extraordinarily specific, we can probably make some improvements to this bylaw while keeping the flavor of the bylaw itself. And that could be done either as a substitution or amendments to the bylaw itself. So any initial comments or thoughts on that presentation? So there were a couple of things that I'm going to bring up just for discussion itself. The first was the chapter name of street names and numbers. There's nothing in this bylaw that talks about street numbers. So my recommendation is that the words and numbers be stricken, so that if it's going to be a discussion of street names, it's a discussion of street names. Street numbers can be redone by residents in cooperation with the post office already.
Oh, Dan?
Yep.
So street names and numbers was to be the title of the article, right? Article 5 of chapter 175, and 175.11 was going to be a bylaw within that article. I think the concept is that the next bylaw to be adopted in order would be on street numbering. I mean, a street number for houses, which I think is actually the bigger issue.
And where it's not being, where that bylaw isn't proposed, there's no language for it that I'm aware of. That's where it makes this issue a bit muddy to introduce something with the anticipation of another bylaw that may or may not get adopted.
Oh.
So that's where I looked at it and said there's no discussion of street numbers. So if there's a section and there's nothing in the section, it could be deemed that the town is intentionally silent on it.
Dan, where are you seeing street number? I'm confused. This is streets and sidewalks. Where are you getting numbers from?
If you take a look at the document itself, there's not an existing bylaw. This is a new bylaw that's being proposed.
It's,
Oh.
Dan sent it in a link. It wasn't like an attachment. It was a link in the agenda.
Correct.
Okay, I missed it.
I'll put it up on screen. There we go. Okay, now you should be able to see it.
Yeah.
So this is coming straight from the planning board's website. So the section is street names and numbers, but there's no discussion of numbers here. So I'm not opposed to, if we were to add another bylaw in the future, then we change the chapter title. I'm just looking at it at this time. And there were a couple of issues just in terms of comments. I made some of these to the planning board, and the full language was not particularly readily available. It was not portrayed as being in near finalized format prior to their meeting. So there are a couple of issues for this. The first one is that it talks about no street shall be renamed if it has been initially named within the preceding 25 years. There may be a reason for an exception to this. And it could be that and I know there's some state law that affects this piece. This one, the 25-year requirement does affect quite a few different pieces. It's the third sentence that actually becomes a real issue. Proposed names must not be identical or confusingly similar to that of any existing way. What is deemed confusingly similar? That's very difficult to figure out. I look at the neighborhood that I live on. I live on Elm Street, which is across from Elm Street, which is next to Elm Square, which is next to Elm. Yes, Elm Street is next to Elm Street. And there are two streets that come together that are both called Elm Street. Is that confusingly similar? Probably. Elm Square, confusingly similar to Elm Street, and you have to get to Elm Square from Elm Street? Possibly. The bigger issue, though, is no proposed street name shall be used to honor any living person or any business entity. Depending upon the name, finding the living person could be very difficult to determine whether it is a living person or not. If there's a person either in town or associated in any sort of way with town that has a name, it could be deemed that they are being honored. Whether it gets, I think the purpose of this is to get to the intent of the rename, but where it's not stated that that's the piece. If there's going to be a rename, we might want to rename something such as Mullen Park. And that could be for potentially Paula Mullen, no relation to Tom Mullen. But if we were to rename or have Mullen Way, it could be deemed confusing in that way as to, is it honoring a living person? Perhaps. So I looked at that, and if we wanted to say any business entity, again, there's lots of business entities. There is not a central registry of business entities in the town. So there is no requirement that all business entities be listed in the town itself. They, depending upon the type of structure, will determine where a business entity is actually registered. So I looked at that, and it seemed to cause confusion as to how we would, who would be the arbiter and determination of whether a name is a living person or not. So that was the first thing that came to mind, just from a language perspective. I think that the language there should be tightened up so that we understand whether that's an intent, whether it's a living person in the town, whether it's someone who was in the town. Is it any living person? How do they do that search?
Yeah, and I think to your point about who makes the call on whether it meets that criteria, if that has to be specified if it's to be kept in.
The proposed street names shall not have more characters than set by the DPW regulations. I haven't, Tom, you might be able to help as to where those DPW regulations are actually codified. Because I haven't seen actually regulations by the DPW on this.
No, I haven't either.
What was that?
I have not either.
Okay, so that's where I looked and said, okay, because they've made text really small when they need to be. And so it's referencing something that could be problematic for that, because street signs can be adjusted, and depending upon what someone is trying to do, I could see it where it becomes an issue. So those were a couple of the issues in A, and if there are ways to reconcile that, I'm certainly open to it. I'm not opposed to having a bylaw for street names and changing names. I just want to make sure that any bylaws that are getting added, at least while this committee is in place, if we have the ability to improve them, that we do so.
Dan, did you say that there was a state law that sort of required this first clause around a street can't be renamed within 25 years of a renaming?
Do you want to address that?
Yeah, yeah, there is. You see, at the end of the first paragraph, it says this bylaw shall be construed and applied consistently with the Mass statutory procedure for street naming as set forth in Chapter 85, sections 3, 3A, and 3B. That's where this comes from. Some of the more arbitrary items in here are there only because the legislature requires them.
And does the legislature, Dan, did you say that, or maybe Tom, you know, did the legislature allow for exceptions to that 25-year piece?
No, I don't think so.
Okay.
So for section A, any suggestions on how to tighten this up while preserving the intent? And Tom, I know you've been more involved with this since since it was brought to you. And if you've got suggestions, again, the goal here really is improving it. It's not to gut it. It's not to get rid of it. It's just to make the language tight.
So Dan, ultimately, the decision whether to rename a public way, and if so, how, falls to the town council, you know, our version of the Board of Selectmen. And it's supposed to be informed by the results of the planning board's hearing. But the purpose of the bylaw, I think, is in part to set forth criteria that should be considered by both the planning board in its recommendation and the town council in its decision. And one of those criteria is this name identical to or confusingly similar to another existing way's name? So I wouldn't bother trying to sharpen the point on that. I think it simply gives the town council marching orders about what they are to weigh. Another way of looking at this is this bylaw provides the town council with an excuse to say no to a whole lot of bad ideas. Now we can't do that. It's confusingly similar.
And I don't have a problem with the concepts in here at all. I'm just trying to get it so that the language is very specific so that there isn't confusion. Because we could have, you know, just as a suggestion, there's a street in the west side that happens to abut several nice parks and so forth. We could rename it, you know, I'm thinking of Jordan Terrace. We might rename it to Mullen Way in honor of the memory of Paula Mullen, who loved to take walks and, you know, support the physical education of students in this town. You might find that to be potentially confusing if you have Mullen on Mullen Way, just for the sake of discussion. So that's where I'm getting to. How do we determine particularly the honoring of living person or business entity, or if it's to honor someone who is deceased, you know, how do we is there a time bar? As there is for many places and many buildings.
Do we need to provide alternative language or just say, no, this isn't it?
We don't have to actually take any action on this. It's a great question. We don't have to take action. We can provide alternate language, which we could present to the planning board prior to town meeting, and that they could potentially request to be adopted. We could also recommend on the floor that alternate language be done. I would personally prefer to bring it to the planning board if there's better language options, so that it can be incorporated into the final motion itself. And my impression after their meeting is they would be welcome to changes as long as the intent is preserved.
Right. I agree. I just tend to agree with your analysis that the goal, or whoever's analysis, the goal is to create some sort of eligibility criteria so that you can exclude things that are, you don't want to spend time on for whatever reason. But I think like that can be, when it's the way that it is worded right now, allows for a lot of subjectivity. And so it's like, who's in control of making those decisions of what's eligible?
And I think our town barrister addressed that to some degree. The final arbiter is our town council,
Okay.
CIL. So town council, SEL is saying the town council, CIL is ultimately the arbiter of any final determination. But this outlines a process for that. Is that a correct explanation? Tom, that's to you.
Yes, that's right. Yeah, I agree.
So the other piece to this is figuring out whether an intent, a proposed street name should not be used to honor any living person. It could be that that language should not be so specific as to honor any living person or any living person in the town. It may be that we want to have a little bit more specificity, because I take a look at some of the existing ways where this would not be allowed. An example would be Edgewater Drive, because Edgewater is actually a business entity. You've got lots of business parks where the park is owned by and streets that are effectively owned by a name that's a street itself. And I could see that potentially then becoming a conflict of not for even subdivisions. Okay, so you've got a subdivision that can no longer have the same, you can't have the landowner be the same name as the street, because then you'd actually have a conflict of the street name, because it's a business entity by definition. So that's where I'm just looking at this saying it may be easier to say the names should not be haphazard, should not be named after trade names or something more specific than just a business name. Thoughts?
I mean, I see what you're getting here, because I mean, even if you say, if it says like someone's dead, I mean, there's also, I mean, I don't know how to explain this, but there's always someone else that's in this world with the same name. So how do you almost like pigeonhole yourself, right? In a way, because if you want to name it after Tom Mellon and he's passed away, but there's also, I mean, technically there's probably another Tom Mellon in this world. So in this, could be in the city or the town. Is that to say you can't name it because there's another Tom Mellon that's alive? You know what I'm getting at?
Well, the bylaw says no proposed street name shall be used to honor any living person. So it has to look to the intent, because almost no surname is unique.
And I don't think we have any current streets that have full names. And what I'm thinking of is like Boston, which actually does have streets that are honorary streets. So there's MLK Drive and things along those lines, which have full names. We don't have, I don't think we have any equivalents at that level. but figuring out that it's the business entity, I think, becomes a bigger issue, because if there is a development that does want to have a component, it should be there. It should also, if we're going to put limitations, put something along the lines of, for street names, especially if this also qualifies for new street names, that it can't be vulgar or defamatory in any sort of way either. So an example that came to mind is there's a development that's currently being proposed, and I believe that there was a determination issuance by Cabot and Forbes over on Quantipout Parkway, which that's a very hard word for many people to say, and they might want to theoretically rename that to be, say, the Q way or something like that, which in today's political climate might not be a wise choice. So we may want to just put, if the intent here is to give guardrails, we may want to make the guardrails a bit clearer. Because I think that if it's to get to intent, then that intent really should be quite explicit.
Can you just say that any proposed street names will be under review from, I mean, or do you want to just give them a guideline? Can you just say it'll be under review from the town, from the planning board? Or, I mean, do you want it set in stone? I mean, I don't know. All proposed names will go
Isn't
under
that
review.
Isn't that already in the process though? Like the planning board has to vote on whether to recommend it, and then the council has to vote on it ultimately, I think.
Yeah.
So presumably these are considerations that, it's not an exhaustive list of considerations. Like the town council can include a consideration that goes beyond this list.
Is that right?
Tom, I think that would go to you.
Well, I'm looking now at section D, action by the town council. If the town council declines to make the name change, it shall so inform the applicant. If the town council approves the name change, in addition to notifying the applicant and the town clerk, it shall request payment. I mean, I think a fair reading of this is that it does circumscribe the discretion of the town council. Well, no, any person suggesting the name. Yeah, it does, because let's say a member of the town council wanted to change the name of a public way or a private way that had been open to use by the public. This bylaw says even he has to start by going through the planning board. And by the time the question reaches the town council for a vote, this suggests it would be an up or down vote. Either they approve the recommendation of the planning board or they disapprove it.
And the way that this reads is that it only applies to name changes, not the initial adoption.
Yes.
So we may want to get a little bit more specific as to what those guidelines really should be if there's going to be a street name change. It could be that some of that is handled through a process. We may want to come back to section A. Section B has some other pieces in here. The first one is the proponent shall file an application with the town clerk together with filing fee of $800. When I asked where the $800 filing fee came from, because fees are supposed to be attached directly to hard costs. That's the first sentence.
Yeah.
There was no way, the answer is, well, that's what other towns charge. It wasn't that's the cost of the street names because there are no costs incurred at this point for the application itself. Because the town has not incurred costs at that point. In addition, this also precludes the town, such as the town council, from on their own accord, or the planning board on its own accord, making a request to do a name change, which could very realistically happen as information is found out about people, events, and history gets clarified over time, and there may be a request for a name change. There should be a way to have an alternate process that doesn't require a filing fee, let alone one that could be deemed significant.
And
But-
prohibited, yeah.
Because again, fees, we haven't dealt with fees much in this committee yet, but in the last bylaw review committee, every fee really did require justification, down to dog licenses. The cost of the tags was, around, I think, $5 to get a tag processed, and that's what the cost ended up being. So it's not a way to raise funds, it's a way to cover costs. And here it doesn't really explain that piece, especially where the cost for the name change itself has to be borne by the applicant separately. So not quite sure if there should be a filing fee for the name change, just to put the actual application itself. Part of that, I think, of having a fee is to cover the initial discouragement of someone just doing it willy-nilly.
Oh, Dan, let me speak up in favor of a fairly punitive fee. And I agree with you that we technically can't charge more than we reasonably anticipate is necessary to cover our actual costs. But you don't want to encourage people to be profligate in this kind of thing. This is the kind of thing that occupies so much time in town government, people wanting to name every room in the town hall after somebody. So I think I actually think that if a town sets a fairly steep fee, it's in part intended to discourage frivolous applications. However, there are some actual costs to be covered here, mostly those concerning the public hearing, which involves publication in the newspaper on 2 separate occasions.
That is a different set of costs that I'd recommend that we figure out that the applicant potentially be responsible for separately, because we'll get to that. That cost could easily exceed $800 very, very quickly. We'll come back to the Quantipout Parkway as an example there in a moment. So the $800 is not that costs couldn't be computed. They could, but depending upon the way itself, I think it's Cedar Court, which has, I think, 4 houses on it. If they wanted to rename that because Cedar Court is off of Cedar Street, that could be deemed confusingly similar, just for the sake of discussion. And it's currently a private way. If they wanted to change that, it could be deemed expensive. And we may want to put in an exception that the fee can be waived by the town council, who ultimately is going to be hearing this anyways. So, and there may be reasons that the town council on their own behalf or the planning board wants to do a rename. It could be to honor someone who is significant in the town. It could be and is no longer living. And an example of that might be General Galvin. So if they wanted to rename a street to Galvin Way or something along those lines, that currently would require an individual pay $100 go through, whereas it might be something that a board says, yes, this is something that is an appropriate use of government, and so maybe that an elected board has to do that. So there seems to be a need for a circuit breaker on the back end, or there could be a person again who was revered and then information came out that they're no longer as respected as they once were when the street was originally named. And so the desire to change that name could happen after the fact. That typically happens decades later, but it could absolutely happen here.
Is this a non-refundable 800? Is that what, I mean, if they pick a name and it's not accepted, then they don't get the money back, right?
Correct.
That's right.
Should that be put in there, or was that just assumed?
I'd say there are costs incurred with just going through the process. You know, it says section C, prior to the public hearing, the fire chief, police chief, town engineer shall give his or her written report. You know, there's time on the part of town employees in the process, even if it doesn't get approved by the town council. So I could, you know, see either way, but, you know, I don't necessarily think it needs to be waived or returned if it is not agreed by the town council.
No, I'm fine with it, non-refundable. I just wondered if we should add that to it, you know? I think 800 is fine. I don't think that's steep at all. I mean, the way the economy is now, anyways.
Tom, would there be an easy way in language to allow for a waiver?
Well, you could, the political problem then is everyone's going to ask for it. And that makes it very difficult to say no.
But the idea being that if the name change doesn't come from an individual, it then comes from the board itself.
Oh, well, one thing we might well want to do is to say that this fee only does not apply to a request made by vote of any board of the town. Yeah, because I think no one who's had their fingerprints on this has thought about this as coming from an official source. This has been, everyone's been thinking that this relates to a private request.
And I can see it going both ways, because again, the road that runs right next to the Galvin Middle School, I could see being renamed to Galvin Way, just as an example. And to require that it is currently, I believe, an unnamed road. So to have something along those lines would certainly make sense to have that come from a public body.
Yeah.
The other aspects to this is the town clerk shall also assemble a list of the names and addresses of all owners abutting the way in questions and of all persons residing at such properties, and shall forward the list together with the application to the planning board for a public hearing. That can be a very onerous task on the town clerk in two ways. One is a list of names and addresses of all owners, of all property owners abutting the way. If someone were to put in a request and to rename, say, Main Street, that would require the contact of everyone on Main Street, which is a long street in the town, as well as all of the abutters of every road that connects up to Main, that it directly connects to Main Street. So all of those abutters, you're now talking realistically hundreds, if not over 1,000 affected properties and people who are residing there. The people residing, it becomes actually really challenging because I don't believe the town clerk actually gets that list. And if you take a look at properties such as Quantipout Parkway, once the Cabot and Forbes property is built, or you take a look at the Grayson Lofts over on Foundry Street, which is predominantly rentals and hundreds of rentals. That I'm not quite sure how the town clerk would have access to that information to be able to assemble that list. And to the understanding of the reason for it seems to make sense, because everyone who lives on a way that's getting adjusted or it's an access road to it will potentially need to notify lots and lots of people. If your address changes, if you've ever moved, you know how much work it is. It's effectively similar to that. So it can be a significant amount of work. I'm not quite sure how to address the residing at such properties.
So Dan, I think the town clerk would refer to the street list for that information, because that's supposed to catch renters as well as, well, it's supposed to catch people where they live, whether they own or they rent. And it doesn't necessarily catch all owners of abutting properties, because sometimes the owner doesn't live there.
It's only designed to catch the registered voters at properties, not the transitory, not the transitory persons residing. And it only is as of the date that it's filed within the usually January of each year. So that information gets stale really fast on rentals. And you're having an impact potentially quickly, because it says within 30 days, that could impact someone in a really significant way. So that's where, again, I'm not opposed to the concept here. I'm just looking at the mechanics as prescribed here becomes a bit challenging. Because I don't think the town clerk has any reason to keep up with who is actually residing at properties, let alone properties that have, and we have quite a few halfway houses and others where people are residing there. Many of those residents do not necessarily even necessarily vote in town, nor would be listed on the census. Some are not. So I'm not quite sure how to square that piece.
Well, all I can say is that the law does sometimes require that we identify persons residing, and we just have to do our best. For example, every time a new public way is laid out, the selectmen are required to hold a layout hearing. And in advance of it, they are supposed to physically leave a notice of the hearing and the proposed layout at the home of everybody who lives at the on the way. And that's whether or not they own the property.
In some ways, that may be even more applicable here, because again, similar to a subdivision, you're now impacting people's lives very directly. Because if their address is changing, let alone mid-year, all of a sudden, where you think you live may no longer be considered valid. So I look at street name changes as being a really significant issue for people, especially who are transitory. And so it's just a matter of how do we reach them? Because if someone were to find out after the fact that, oh, you thought that you were on Quannapowitt Parkway and all of a sudden you actually live on Q Way, it could become a very real issue. Depending upon the other pieces that people have, they may or may not want to attend a hearing. They may need to be aware of what's actually happening. Depending upon the relationship they have with the owner of the property, they may or may not even get notice from the owner. Because to your point, many property owners do not live in town, especially of the larger properties. Businesses are similarly situated. If a business has a significant equity in the name of a street, that becomes a real problem if they don't get notice. And businesses were not actually mentioned in this. So I'm just trying to figure out, how do we reach people who are affected? And maybe the language should be those directly impacted by such a name change.
Well, I think that's vaguer than persons residing.
I would think of it in addition.
Well, then you open yourself to the, well, one, you multiply the amount of work which has to be done. And two, you create an ambiguity. It's clear who resides at a property, but it's not clear who's going to be impacted.
And what about businesses?
Yeah, you might want to do that. Sure.
I think you have to include businesses as a business owner. If that street changes, that's a lot of headaches you have to go through.
Headaches and very significant costs.
Yeah.
So an example, if Edgewater Drive were to be renamed, it would impact hundreds of businesses. Just because of the nature of the number of businesses that are on it. Main Street, another example. And even individuals who operate home-based businesses, again, they would need to really get notification. Purpose here is to make sure people know about the issue. And they really need to get that notice.
So Dan, I have a quick comment.
Sure.
If this sounds like it's gonna be if it's a main street and it's gonna affect a lot of people, shouldn't there be some kind of I don't know, something that says that maybe it should get approved by the people living on the street first, or maybe they should be talked to first, or asked if they want, if they want the street name changed. I mean, you know what I'm saying? Like, if someone just comes around and wants to change the name, and there's a bunch of businesses they have to change. I mean, maybe half the people on the street don't even want the name change, and all of a sudden the street they're living on or whatever, basically just gets changed. You know what I'm saying? That should be added to this. I don't know. Do you think that? I mean, I don't know. I just don't think it's fair if someone just wants to change the name, and then next thing I know, it's coming to the committees. I don't know. It just seems funny that there's nothing in here that maybe they need a list of people that approve of it before they even come to. Am I going down a rabbit hole here, or?
Joe, I think you are, because that's why we have a hearing. That's the purpose of the hearing, to solicit input from everybody who lives on the street.
I guess. Sorry.
You can go.
I was just gonna say I agree that is the purpose of the public hearing. On the other hand, to your earlier point, Tom, about not wanting sort of like to encourage a lot of name changes and the incurring costs. I wonder if there would be value in, like, you have to have at least, I don't know, some number of people on your petition to change the name before the town goes through this whole process of having to document every affected person and send out all these notices and hold a public hearing, so that it's got to be more than just one individual person who happens to have $800.
Yeah.
I thought a petition option or pathway seemed good too, in that it is less prohibitive than like cash and does a little bit of the legwork in advance of even putting it in front of people who have to do additional legwork. Like it can be another type of eligibility criteria that might just, like, it might die there. Maybe not.
I I believe the city of Boston, because this came up when they changed the street near Fenway Park, requires like 80% of the owners on the street to sign a petition in order to even get the process started. So it kind of, even to get the process started, you do need that buy-in from the people who actually live on the street.
Well, it says in the public hearing section, it says prior to the public hearing, the fire chief, the police chief, and the town engineer shall give a written report and recommendation. So what guidelines or what are they using in order to either approve or deny this? So it sounds like there's some input, at least by the fire chief, the police chief, and the engineer about the change itself.
That's right. And the only specific instruction to those people and the planning board about what to consider is that the name mustn't be identical to or confusingly similar to that of an existing townway. And it shouldn't, it can't be used to honor any living person or business entity. And it has to have a character limit.
But the character limit is defined by DPW.
Yeah,
Right.
that's right. So beyond that, yeah, if you can think of other criteria that you'd want these people to consider, then this is where to state those criteria.
Would it to the discussion that came up, would it be reasonable to require a petition to have either a percentage of property owners or some sort of fixed number of signatories in the town so that they can then be verified, to discourage, to your point, Tom, to further discourage frivolous requests and to put some of the legwork, especially of the concept, ahead of the issue.
Mm-hmm.
I agree with that point, and I also like the idea of widening it so that it doesn't necessarily. There could be two potential criteria. One could be just looking at people on the street, but I like the idea of also giving it the option of having a certain number of people in the town, because I think there could be a reason why it's in the public interest to change a street name, but the people living on the street, as per the earlier conversation, sort of have a lower threshold for wanting that change to have, or a higher threshold for wanting that change to happen. And so I don't know that we would necessarily want to say 80% of the people on that street want the street name to be changed, or we'd want some sort of way of getting around that if it was in the public interest for some reason or another.
So it could potentially be an or.
Yeah, I was thinking one way of expressing it might be the petition would have to be signed by at least X number of Wakefield residents, or Y percentage of people living on or abutting or owning a property that abuts the way.
I think that would be smart.
Yeah. What would be appropriate? Oh, and it would probably be the greater of those two, right? You'd want to set a.
I would think you would need at least 2/3, no? I mean, 2/3 on the street, and I don't know about the town. I don't know how you figure that out.
For what it's worth, the number that immediately comes to mind relates to town meeting, and that's 200. If we're to go with the raw number,
Mm-hmm.
that just brings the issue to the planning board directly, because that would be on a wide basis. To Catherine's point, if there is a reason to do a name change to get 200 people, it's work, but it's not an unreasonable amount of work. We could also, other numbers that come to mind is the number 50, which is the number that we have prescribed for getting on a ballot. So we could certainly, which is not a, it's not a hard bar to realistically raise, but it's also not trivial either. 200 is a lot more work.
Dan, can you hear me?
We can, Bob.
I might suggest 25. And the reason for that is I think something's missing from this proposed bylaw as well. Because section 3 under the Massachusetts general laws, the one that's applicable, chapter 85, section 3, has an appeal process. So that's one piece that's missing. It says whenever a board or an officer having jurisdiction has changed the name of a public way, and that's been in use for 25 years or more, there's a right to appeal. And that appeal is taken within 30 days after the name change and shall be by petition of at least 25 inhabitants of the town. So number one, I think this appeal process under state law should probably be listed in this proposed bylaw under in the last section where it talks about action by town council, maybe either in D or with a new section E. But since 25 is what's in the state law as far as appealing a name change, it might make sense to make 25 the threshold for asking for a name change.
I hear where you're coming from. I appreciate the additional research, Bob. My thought on it is 25 to request a name change seems very low because of the significant impact that it would have. The appeal does not guarantee that it will be successful. And so to have a higher bar as opposed to having a question that goes back to the very board that already made the decision, because all it does is basically say that you have to then revisit it. It doesn't change the process itself. I would think that a higher threshold would be a bigger deterrent, and I think there can be an alternate that would be lower. So if we were to do a raw number for something of public interest, then it would be, I'm thinking my recommendation would be either the number 50 or 200, or the option of probably 80% of the residents and property owners combined, residents, property owners, and businesses combined on the affected way itself. So it could be the lower of those two numbers. Because if we were to look at like Cedar Court, which I think is 4 properties or 6 properties, if all but one of them wanted to do the name change, to have to get 50 people seems like a bit of overkill for them to do that, to go through that process. That's just my thoughts, but to have the number 25, it feels like that's too low of an impediment if the goal is to discourage people from doing this process, which is going to cause a lot of work to the town. We want to make sure that the process is done really thoughtfully.
Well, the planning board, it looks like if you read their proposal, literally, it's one person. Is that not right?
As currently stated, that is correct. And so that's where the idea that Catherine had of making sure that we have we raise that bar so that it's not one person.
Well,
It then becomes, it requires a plurality, but there should be multiple ways to get to that plurality. So an example, like when they renamed where Fenway Park is on from Yawkey Way, I do recall the discussion, I believe it required 80% of the businesses and so forth to agree to it for the hearing itself. And to do something similar as one threshold, or if something is deemed of extreme significance to the town, to have another threshold that would override that, regardless of the number that would allow to.
This might be a naive question, and I know I'm not on the bylaws review committee, but
You're an
It's-
honorary member.
It seems to me that I don't understand why the planning board isn't going through this. Like, you guys could go back to them and say, you should add a threshold of how many people should, X number of people should apply. You have to make sure this comports with state law. So you have to add language in section D or create a new section E that says, explain the right to appeal. Either lay out what the right to appeal is, or say, somebody has a right to appeal under Massachusetts general law, chapter 85, section 3, something like that. So you guys are spending a lot of time, well-reasoned, in going through somebody else's proposed bylaw, as opposed to maybe going back to them and saying, these are the questions we have on this. Because I can tell you, before this bylaw goes to town meeting, it's going to come to the town council. And we're going to sit down and we're going to go through this stuff as well. So you got 3 different bodies that are going to be going through this bylaw. But it seems to me it might be prudent to have the planning board readdress some of these specific and very good issues that you all are raising. That's just my 2 cents.
That's the purpose of this discussion, is to make recommendations so the planning board, as the initiator, will have feedback and can ideally change the language prior to town meeting itself and still be within the 4 corners of their warrant article.
Okay.
Upon learning that this was going to go forward, I attended their last meeting and had a similar discussion with them, recommending that they get additional feedback, and there was not much interest by the planning board members of getting additional feedback. So they voted to move it forward as is, which is absolutely their right.
Sorry, just one other question going back to something we initially talked about around this 25 years threshold. What is the value of repeating that threshold if it's already in federal law? Or sorry, not federal law, state law. So if state law were to change and lower that threshold to say 10 years, would we then be stuck with this 25 years sort of vestigially? Or is there, what's the value of repeating something if it's already in state law?
Yeah, I don't mean to suggest that I'm a big fan of this bylaw. I don't know that it's all that necessary. And I'd be content to rely on the existing state law. I think this, and I'm sorry, I don't have a copy of the state law in front of me, but I think this embroiders or elaborates on the state law in some respects. But I don't think it's been a real problem.
I'm not aware of it. I'm not aware of the catalyst for this particular bylaw coming up. And one of the questions that I did ask the planning board was there an urgency for this to come up at this town meeting? And the answer was it had been brought to them about 18 months ago, and they did not see a reason for any further delay. That was the discussion in short of why it is now coming up at this point. So one suggestion, and hearing these comments, and then there have been some additional comments that have also come in to our general email through this by a member of the public who's not talking directly, and that's Vinny Cheka. I'm probably getting the name pronunciation wrong. My apologies. Just asking some specific questions about this that were also questions that were submitted to the planning board, and he did not get an answer to this. is that with these questions, I think we can make a recommendation to the planning board that they take this for indefinite postponement at this town meeting or withdraw the article. So that it doesn't cause problems going forward and they can repropose it with once it has had some additional vetting. Because what I'm hearing is that there isn't a problem with the overall concept of having a street name change process. It's just the mechanics here seem to have work on it. And so if we want to take a vote as a body to make that recommendation, I have no problems forwarding that recommendation on to both the planning board, town council, and if necessary at the town meeting itself. So just want to throw that out there, and I leave it up to all of us on this call as to how we want to handle it without belaboring getting into every piece of language here, because there is still even more. We haven't even gotten to the action by the town council. And, you know, I'm sure that Bob is chomping at the bit to get to, you know, what happens if there's components as well as some of the cost pieces that the town might have to bear for notice and so forth, and how that piece is handled. Because there was discussion by the planning board that all notices had to be by certified mail. And if you take some of the larger properties, you're now talking about, you know, 400, 500, potentially 800 people, 1,000 people, each getting certified mail. You're talking thousands and thousands of dollars just in mailing costs.
This is just me speaking as one member of the town council with my own opinion. And I'll make this very basic. So Massachusetts General Law, Section 3 says the town council or a board having jurisdiction, which is us, has broad-based power to change the name of a way that's been in use for over 25 years. It is very broad-based. The planning board is looking to add a lot of restrictions to that. It can't be identical or confusingly similar to any existing way. It's got an entire process where a lot of other entities in town have to vet this and make recommendations to the town council. What the planning board hasn't done, and once again, this is just my personal opinion. What the planning board hasn't done is come before the town council and say, here are the reasons why we think you should restrict the power that Massachusetts has given to you. And this is why that power should be changed from what Massachusetts has provided to a board of selectmen or a town council. And those would be the questions I would ask the planning board. So that you guys are now looking into this substantively. But I think before we even get there, I'd like to see the planning board come before us and explain why this is necessary and why we should abdicate some of our responsibility and power that Massachusetts general law has provided to us as a town council. Does that make sense, Tom?
No, I see your point.
I mean, this is the first time I'm looking at this proposal tonight, so I apologize for that. And when I was with you guys 2 weeks ago, I just had surgery that day, so I've been out of it for a little while. But I'm looking at the bylaw, and I'm shifting back and forth between Massachusetts general law, and I'm like, I don't understand the need for this. And I'd really like the planning board to come before us first, especially before you all take up a lot of your time when you've got a lot of bylaws to go through.
So that we do, and part of the reason for putting it on the agenda for tonight is because the planning board did take a vote to advance it. So with the way that our bylaws and charter are written, it will go straight to the warrant. So the town council doesn't have the ability to effectively block it from going to the warrant, but obviously has the ability to provide an opinion on it. And so part of this is so that we can make sure that anything that is proposed, the comments that go at town meeting are made with as much reasoning as possible. Because the town council obviously has a stake in this, potentially the planning board has a significant stake in this, and as a bylaw that might get adopted, we obviously would have a stake in it as well. And for what it's worth, our town barrister gets stuck squarely in the middle of all three boards.
Okay,
I
I guess I didn't know they planned to bring it as a warrant article for this town meeting in November. Because we haven't seen the warrants yet. Okay, that's fine. I've said enough. Thank you.
That was what they voted on at their meeting last week, was to bring it forward. So I don't know whether it was in the warrant, because I believe the warrant closed or was closing, maybe it's closing this week. And when it was intended for being included. That was their very clear intent. So just wanted to make that. So do we have any sort of action motions and so forth as to what action we want to take, if any?
I think we should at least maybe send a letter to the planning board detailing some of our comments that we've gone through so far, so they're aware of them. And then we can kind of go forward from that point.
Okay, we can certainly do that. I can certainly draft a letter. I will go through the Zoom meeting and summarize the comments and concerns and send those off. I would send a copy to the town council as well, both town council and town council, just to make sure that there isn't a dearth of information. So that's certainly an option if the committee wants to do that. So is that a motion?
I second that motion.
Yeah, I move.
Okay, so motion's been made by Tim to send a letter. With that, the comment that I'll have is, do we also want to make that as a recommendation of any sort of, in its current state, any sort of action, inaction, or any specific recommendation for how this should be handled that we could or would want to take at town meeting? We can also defer no action, not take any vote on that, and defer that to our next meeting, which will likely happen before the town meeting itself.
Are you going to draft a letter beforehand?
I will draft a letter within the week. And since it's an official letter coming from the committee, you will all be CC'd on it. So you'll get a copy of that letter itself. But the question is, do we want as a board to take a formal opinion as to any action at town meeting or not? And I'm not trying to advocate that we need to, or that we even need to make a decision tonight. I'm just stating that that's another option that we have. While we don't have a mandatory position to give an opinion, we do have the ability to always give an opinion at town meeting as members. And if it's a formal vote, then it gets communicated as that of the board itself. Otherwise, we can only speak as individuals.
So Dan, just to make sure I want to make sure I understand. Essentially, if we were to vote on, let's say our opinion was this, we should vote this down for now because it needs more processing. Then when it got read at town meeting, you or somebody would stand up and say, like, this is the official position of the bylaw review committee.
Correct.
Okay. I just wanted to make sure I understand.
If we take a position, then that is the statement that I would then state. It would not be a scheduled piece like after any financial article. The moderator by our form will always ask in anything financial for the finance committee to make a position. For anything that relates to land, they will ask the planning board for a position. We will not get asked in that way, but if we decide to take a position, I will then go up as during the discussion period and state that as well. But if we choose not to take a formal position as a body, that's fine too.
But we could send the letter and then see whether they respond or how they respond and decide whether or not to take that vote at our next meeting.
Absolutely. Given the timing, I'm not confident that there will be a full cycle of them having a meeting discussing the letter, having a response before our next meeting that is scheduled before the town meeting itself.
Could we phrase the letter to urge them to discuss it before then by saying something like, as currently written, the bylaw review committee could not support this at town meeting
Absolutely.
because of, and then we list some of the things we discussed tonight?
And that's effectively what I'm asking is, do we want to take a position statement on that? Otherwise, it will be the bylaw review committee has concerns with the bylaw, or do we want to state as currently written, bylaw review committee does not support passage as currently written, and would recommends that this issue get deferred to another town meeting after it has more time to ripen, something along those lines. I'll come up with some sort of flowery language. Probably pass it by the town barrister to make sure that there's nothing legally incorrect by it.
I like that option because if it were to pass, it feels like we're just going to reassess it down the line anyway as part of the bylaws.
That is accurate. So you want the option of recommending of making a recommendation for effectively a deferral,
That feels like it makes the most sense.
which in reality is a negative vote, just to be very clear. But I don't want to say that we don't recommend that we don't recommend the bylaw overall, because I'm not hearing opposition to the concept. What I'm hearing is there's issues with the language itself, which is very different,
Right.
than what's happening. Okay. So do you want to have, Tim, I believe you made the original motion. Do you want to have the motion updated to have a position statement?
Yes, I will recommend the letter be also note that we recommend a deferral from the fall town meeting of this article.
Okay. Catherine, I believe you seconded.
I think Joe did.
No, Joe, you seconded. Do
Yeah,
you agree with that? Okay.
I'll second the amended motion.
Okay, so the motion is to send a letter with a recommendation for a deferral as currently written, so that changes can be made consistent with this conversation. The motion's been made by Tim, seconded by Joe. Any further discussion?
Further discussion, I do have a couple, I think other people alluded, there may be comments we have on like item C and D of this. So we're just kind of being general, recommending deferral. Here are a couple items. This is a non-exhaustive list kind of thing. Is that your intent, Dan?
That is absolutely
Okay.
the intent, because we have not had time to go through C and D in depth.
Okay.
So you are spot on. And as I go through the Zoom meeting for this, I will probably pick up that language. That's my current intent. Other thoughts? Lisa, I haven't heard you say much on this. If you have any comments, by all means. We do try to get everyone in on all the conversations. Okay, with that, we will take a vote again by roll call, and I will do it in the order that I see you currently on my screen, because people have moved around a little bit. So Joe,
Yes.
Tim,
Yes.
Catherine,
Yes.
Lisa,
Yes.
Kevin,
Yes.
Lucy,
Yes.
and I will vote in the affirmative. So we have a unanimous vote on this issue as well. Welcome to some of the contentious issues of bylaws. It gets into interesting stuff. Tom, I do feel bad that you are squarely in the middle of all of this and you get to write it, but it's just all in a day's work.
All right.
It reminds me of the old Looney Tunes where you see, you see the fox and the sheep go into the paddock and start chasing each other around, and then at 5 o'clock they clock out and they go off together. Things that happen. Okay, so chapter 51 is on reports. So given the hour, we've spent a considerable amount of time on this one. I don't want to spend too much time on chapter 51 tonight, but I do want to take a real quick look if there's any immediate feedback. Again, there's additional feedback from Eric. This is something that I know he finds very near and dear to his heart. He has a lot of feedback for the annual report itself. So with that, there are a couple of changes that have already been identified, such as things that just for unknown reasons were not updated either in the online version of the bylaws, possibly in the official copy of the bylaws. Things such as the names of committees that have changed, like the Commission on Disability issue is now Commission on Disabilities. And I'm not sure why that wasn't changed specifically, just that's one example of different pieces that are in here and need to be updated for consistency. Any other thoughts on chapter 51 initially? Otherwise, my recommendation is that we will go through this at the next meeting. I want to make sure that Eric has the ability to give his comments in full, just out of respect for his membership and his desire to be a part of this particular process, because this is one of the things that he sent a lot of feedback on. Again, can't share it outside of a meeting, don't want to speak on his behalf. I'd rather him be able to advocate for himself. I think it's in the proper place for him.
And I just had one question on Eric's notes that he sent you, 51-4. Says that's new. New as in doesn't appear, because I don't see that online, a 51-4.
Correct.
Okay.
And that was the feedback that he'd sent previously. He sent more today just on specific things for this meeting. Again, did not seem appropriate to send outside of a meeting. He can advocate for that information as well. That way it's all held during an open meeting itself. Okay, with that, having fun deferring some things, brings us to item 5, update on professional assistance with zoning recodification. So Tom, this one I think is going to go to you. Do you know how things are going with Mr. Bobrowski?
Well, I reported his willingness to serve and his quoted price to the town council at the last meeting. I think they were pleased. So I'm sorry, was there something else that you wanted me to do in the meantime?
It's just a matter of getting through the process so that we can retain him, and also making sure that there isn't a limitation on the amount of assistance from his firm that we can get. Because you'd mentioned that he probably will have a limitation on how much time he can personally give, and we may get associates for other meetings, and just want to make sure that clarification was given so that we're all on the same page. We just don't want there to be surprises, but on either side. As you know, personally, we tend to get into the details and into the weeds. Mm-hmm. And I just want to make sure that that his firm doesn't get surprised by that. Because I suspect that you have much more experience working with other towns. We tend to be a bit more detail oriented than I suspect a lot of other towns are at this level of recodification and going through language.
Well, yeah, I mean, I think you want to think about whether you want to pay Bobrowski or one of his associates what is, likely to be something like $200 an hour to sit through one of our meetings. It gets time consuming, and I don't think any town handles it that way. I think rather, if they want to brood about on issues, they do so at a meeting like this among the members of a committee and their regular town lawyer, who presumably is not billing on an hourly basis, as indeed I am not. And then they bring in the hourly guy only as necessary and occasionally.
Which is perfectly, I don't see us having a problem with. I just want to make sure that the expectation is set correctly, as we are just a bit more detail oriented. And this will be the first time that these the zoning bylaws have been reviewed in depth in decades.
Yeah, tell you what, let me talk to him about, he I think has proposed $45,000 as an overall cost for the project with a certain number of meetings. I think I would propose to him that he give me a per meeting addendum. That is, if we wanted additional meetings, we could get them for X dollars per meeting. And that would allow us to add his or his firm's availability up to the limit of our appropriation.
I think that would make a lot of sense. And again, it sets the expectation for a win-win relationship.
Yeah.
Because if we need the expertise, I just want to make sure that there aren't surprises.
Right.
That seems to make a lot of sense.
Okay.
So it brings us, thank you for that update. And then do you know what the timing is likely for the town council to do the approval so that we can then start that process? Just so that I can have an idea of when we're going to start needing to get into some of that meat and bones.
Yeah. So let me solicit Bobrowski for a proposed engagement contract. And
Okay.
I can bring it to the town council for them to authorize Steve Mayo to sign.
Excellent, thank you. So given that it's the middle of October, that would probably be, I would imagine nothing would probably get signed until either November or December.
Yeah.
The end of November, December. Takes a couple of meetings for some of these things to get worked out where it's not urgent.
Yeah.
So item 6, couple of upcoming dates. Wakefield 101 is on October 20th. For those of you who are newer to town, or those of you who feel like you're newer to town, or you wish you were newer to town, Tom, I think that might, you might apply to that one. You know, you wish you were newer to times. October 20th at the American Civic Center, it's working with the library to introduce people to the different elements of the town itself and how town government works. It's great. It should be a really good type of programs being done with the Wakefield Linfield Chamber of Commerce. Our next meeting, according to our calendar, is November 7th, again by Zoom. That will be day before Election Day for those who are voting in person. Voting is going on now remotely. If you have not requested a ballot and wish to do so, feel free to contact the town clerk or go to the town clerk's office. I do encourage everyone to vote in all sorts of elections. I'm not going to tell you how to vote. Just being a participant becomes very helpful. Town meeting itself will be on November 19th in the Galvin Auditorium. So for those of you who have not been to a town meeting, I don't recall the time for that time. Do you remember whether it starts at 8 a.m. or 9 a.m.? It's a Saturday.
Yeah, I don't.
Okay, so if you haven't marked that off in your calendars, highly recommend it. Voting at town meeting in Wakefield is only done in person. You have to be present. All you need to go in is your name and address. It's based upon voter rolls. So any registered voter is welcome to go to town meeting. It's a truly democratic process, and every registered voter has the ability to speak at town meeting. It will be held in the New Galvin Auditorium. Food and drink are formally prohibited. And I say that because some people do bring in water bottles or other things as needed. The meetings do tend to get lengthy. I don't know how many items are going to be on this warrant or how long it will be, but we are aware of things that are planned, such as the discussion of the Chapter 175 street names, that sometimes discussions will take on a life of their own. And a lot of times there will be updates that will have other components. The other item that I anticipate will be at this town meeting, just to be aware of, is the proposal to have a debt exclusion for a rebuilding of the Wakefield Memorial High School. And that would be to approve, there'll be a request to approve a debt exclusion vote to then be sent to the town voters to pay for the balance of a new high school. So that's going to be an item that will be handled on November 19th in the Galvin Auditorium. That's the current plan that I'm aware of. And I'm sure there's a bunch of other items, such as a financial update and so forth, that usually happens as well. And any other items that would affect this group that you think are particularly aware of, Tom, since you get to write up almost all of the articles?
No, I think that's it.
Okay, so again, I'm not advocating for any particular positions on these items, just making sure that people are aware of it. And if you haven't been to a town meeting, please by all means go. It's a interesting experience. The Saturday town meetings tend to run between 2.5 and 4 hours long. There is no end time. And I do not know if the town meeting starts to go on, if there's a suspended session. Sometimes the meeting will go on to a second session when that session would occur. So typically historically pre-pandemic used to be Mondays and Thursdays alternating. And I have no idea now that we're doing Saturdays what that's going to translate to. So just to be aware of, because the November 19th is right before Thanksgiving, and I'm pretty confident everyone wants to get that meeting over and done with before Thanksgiving. So with that, any final comments by anyone? The feedback that I have, great discussions today. I really appreciate getting people's opinions, great ideas. This is how we get really good input. Everyone here truly is valued and appreciated. All of the opinions are important. Talk to your neighbors, talk to your families, get additional thoughts, because these things affect our quality of life. So really important on this. So with that, we have one.
Ian, real quick.
Yep.
I don't know if you want to throw this out there, but the ZBA is taking memberships. I don't know if you knew that, but it is on the town website. Taking applications, I'm sorry.
There are some other boards that have openings as well. Absolutely. Okay. If someone wants to work to be on the zoning board of appeals, it's yeoman's work. And if you find that you really like zoning, that's where the determinations and overrides really get handled. It's a really challenging position. And really important, because it impacts a lot of people, and it impacts developers. It impacts a lot of different elements in the town itself. The goal of the ZBA is to make sure that any zoning variances are done with the best interests of the town overall at heart. That's the intent behind it. So thank you. And if anyone wants to apply, by all means, feel free to do so. There's no exclusion on the number of appointed bodies that you can be a part of in Wakefield. You're only allowed to be a part of one elected body. You can be a member of as many appointed bodies as the appointing authorities decide to create for you. So with that, we have one final vote that is needed. We need a motion to adjourn.
I'll make the motion to adjourn.
Okay, Joe wants to get out here quickly. So Joe is making the motion to adjourn. Who wants to second, who has not seconded something today?
I'll second it.
Second.
So we've got a second by Lucy, a third by Lisa. You can get that into the notes, Joe. That way Lisa gets there. She gets a third. So with that, we'll do a roll call vote. I'm going to change up the order a little bit. Lisa, you get to go first on this one.
Yes.
Lucy,
Yes.
Kevin,
Yes.
Catherine,
Yes.
Joe,
Yes.
Tim,
Yes.
and I vote in the affirmative. So with that, the meeting is adjourned at 8:53 p.m. Thank you, everyone. It's been fun, and we'll see you all in a couple of weeks.
Okay.
Good night.
Thanks.
Have a
Good
good
night.
night.
Good night.